Welcome to our today's Coffee and Consulting about Mind the Red Flags regarding your cross-border work trip. Today is our journey to Austria, and I am happy to be here with our partner from ATUS, Mr. Obernberger and Ms. Buttlinger, who will provide us with the best insights and best tips and tricks, and also the information what we need to do and what we need to consider when going on a work trip to Austria. My name is Friederike Ruch, and I have the honor to discuss with you together and with our partner today's Coffee and Consulting. Before we start, on the right-hand side, you will find the slides from today's presentation. So if you would like to download them, then please do so. They are available during the presentation. The other thing is that also on the right-hand side, you will find a box where you can put down all your questions about the today's topic. Please write them down while the presentation is ongoing. We will try to answer them, if possible, during the event. If not, and that is quite possible because I had already a quick glance on the slides, and there's lots of information you will receive. So most likely we will just pick one or two questions, and the rest we will answer afterwards. So for sure, or be certain, you definitely will get an answer for all your questions. Then I think we also should just start with it. Where we are going today, as I said already, we are flying to Austria, and Austria is in the middle of Europe. We've put here down a card so you see a bit of how Austria is split in the different areas, and Mr. Obernberger and Ms. Buttlinger will provide us then, I think as well, the insights about the most likely also different aspects from those. Before we start as well, there is one information page where we have put down the link below. There is some general information you can get from that website. We think it's quite useful to just get for the first time. If you are thinking about going to Austria, you will get some ideas what you need to think about. Now, as always, if you send people to work in another country, just the information you will find online or in the internet most likely is not everything what you need. And as we know that, we have, as already said, our partner who will help us all the time with all the questions around cross-border work in Austria, and who will be able to give you all the insights about it. Therefore, I also would like to hand over the word to Mr. Obernberger or Ms. Buttlinger for the start, and the stage is yours.
Yeah, thank you very much. This is Michael Obernberger speaking from ATUS. Next to me is my colleague Sieglinde Buttlinger, and we are more than happy to be your flight attendants for today for your trip to Austria. So, what is our agenda for today from an Austrian perspective? Maybe we can go to the next slide right now. Thank you very much. So the agenda for today is, first of all, what are the requirements for being able to work in Austria? So we are talking a little bit about work permits. Then in the next topic will be taxes. We're talking about the 183 days rule, factual employer or economic employer. This part will be covered by my colleague Sieglinde. She will also be talking about social security. You may be already familiar with. We are talking about the A1 form or certificate of coverage, as well as insurance topics. We also try to cover labor law and compensation. What are the mandatory provisions, issues like minimum salary and so on. Very exciting topic, travel, the entry requirements, some pandemic restrictions, quarantine, topics like this. And we will close with the compliance and process. It's about tracking, constant and regular review, and some policy tips and tricks, let's say. So just jump into the first topic. It's about the working permits. You have to differentiate between EU and third countries. For this purpose, Switzerland is treated like being member of the European Union. So a little bit extended European Union, let's say. So if your citizenship in EU, then you have in general free access to the Austrian labor market. You can be employed without special permits. You have to think about or to keep in mind, if you stay longer than 3 months in Austria, then you need a special document. It's called Anmeldebescheinigung. And if you're staying for more than 5 years uninterrupted, then you get a confirmation that you are here for Dauer. It's called a Daueraufenthaltsbescheinigung. Yeah, also relevant in this perspective is persons accompanying the employee, for example, spouse, registered partners, etc. And they can also stay for 3 months without any visa or other restrictions or procedures to take care of. And they also have free access to the labor market. Then the other side is non-EU, non-Switzerland. So we are talking about other countries, workers who are citizens of another country. Then there is the need to have a residence permit, and there are different permits. It's the Rot-Weiß-Rot-Karte, it's red, white, red. Of course, this is linked to our Austrian flag because this is red, white, red. And then to fulfill European Union requirements, we also have a blue card, blaue Karte EU. What are the preconditions to receive these permits? Presence of health insurance. You need suitable accommodation, regular income. The residence must not pose a threat to public order and security. Existence of gainful employment in Austria, and proof of knowledge of the German language. There's the A1 level required. And after 5 years of uninterrupted residence in Austria, the person is entitled to apply for a permanent residence, and this is connected with unrestricted access to the labor market. On the next slide, we will go in more detail regarding this red, white, red card. It's mentioned here with Rot-Weiß-Rot-Karte. Like I already said, it's for third country nationals, and it gives temporary allowance to settle and work. In Austria, it's linked to certain employers, or it's linked to the employer you are going to work. So you cannot leave the employer and start working with another employer without any other application forms. In general, it's issued to highly qualified persons. For key workers, there is, how to say, a pointing system. So you need to characterize the working position you would like to cover with someone from a third country. And you get points for education skills, for language skills, and so on. And nowadays, it's hard from an Austrian perspective to get some key workers in some special fields and industries, and therefore right now there are pretty good chances to meet the minimum points you need to receive this red, white, red card. In addition, there is the red, white, red plus card. You can apply for this after you received, at least for 2 years, the basic red, white, red card. And the big difference is it's easier to bring your family members, it's unrestricted access to the labor market, and yeah, it's the employee receiving more rights and, let's say, more freedom in choosing employer. Sorry. Then we already mentioned the EU Blue Card. It's for third country nationals as well, but this attracts only to very high educated people, for highly qualified academics to be precise. And it's also linked to minimum salary. It's mentioned here right now, it's more than 45,000 euros. Again, it's also valid for 2 years and can be extended. And here the goal is to receive the red, white, red plus card. So this is, let's say, the best permit you can receive for yourself, in being free of choosing your employer, and as well as for family members. Yeah, that's the basic for the working permits in Austria, to give you some first insights and awareness. From our side, in case we are dealing with these topics, we have very good experience with, for example, the Austrian Business Agency. We have close relationships with the AMS. This is the Austrian Arbeitsmarkt service, so they are responsible for these permits, and yeah, we can assist you in this field. The next point on the agenda is about taxes, and therefore I will hand over to Sieglinde.
Yes, hello also from my side. I will explain the 183 days rule. What is it about? It applies when an employee works for his or her employer in another country for a limited period of time to fulfill an order for the employer. So this lies in the interest of the employer. I have an example here. An employee who is a tax resident in Austria is seconded by his Austrian employer to Switzerland for 5 months. And Article 15 of the double tax treaty between Austria and Switzerland regulates that tax liability is in the country in which the work is carried out, unless the employee does not spend more than 183 days in the other country. In this case, the other country is Switzerland, and the remuneration is paid by an employer that is not resident in the other country. So is not paid by an employer not resident in the other country, so in Switzerland, and the remuneration is not paid by a permanent establishment the employer has in the other state. In this case, this is also Switzerland. The conclusion is that Switzerland has no right to tax the income because the employee does not stay in Switzerland for more than 183 days. It is important to mention that it is the days of stay that count and not the days worked. So in this case, Austria has the full taxation rights, and Switzerland cannot claim any taxes. On the next slide, I will explain the economic employer. The 183 days rule does not apply if the employee is posted to another state and the personal costs are charged to the company in the other state. So in this case, the other state would be the economic employer, because the employer in the host country pays for the remuneration. So I have also an example here. An employee is posted by his Austrian employer to the sister company in Switzerland for 5 months. The personal costs are charged to the sister company in Switzerland. So the interest lies with the hosting company in Switzerland, and Article 15 of the double tax treaty between Austria and Switzerland applies here as well. The tax liability is again in the country in which the work is carried out, except where the recipient does not stay in the other country for more than 180 days, which would be the case here. The remuneration is paid by an employer not resident in the other country, that is not the case, because I mentioned already that the employer, the economic employer, is now deemed to be in Switzerland, and the remuneration is paid by a permanent establishment of the employer in the other state. Would again be the case here, but not or no, the three conditions are not fulfilled cumulatively. So in this case, we would have the taxation right in Switzerland from the first working day that is exercised in Switzerland because of the personal costs charge. And the taxes that are paid in Switzerland are credited in Austria. And all other working days that are spent in Austria and third countries, those income attributable to those days are taxable in Austria in the resident state of the employee. Then the factual employer. In Austria, we have the definition of the home office permanent establishment. In the factual employer is an employer who has the de facto control over the residential premises of the employee through the employee's use of the home office for business purposes. That is the case, for example, if the employee uses the company laptop or the mobile phone of the employer, then this gives the employer the de facto power of disposal of the private apartment of the employee. The preconditions are that the home office is not only used occasionally, so more than 50% of the working time, and the employer does not provide a working space in his premises, and the employee claims, for example, his or her home office costs in the tax return. I have an example here as well. An Austrian employee works for his Swiss employer from his or her Austrian home office. The employer does not provide a workplace on its premises, although the activity would require one. Possible establishment of permanent establishment of the Swiss employer in Austria. This would be scrutinized in more detail. The employer would then become subject to corporate income tax in Austria, and the employee is allocated to the permanent establishment and would therefore be taxable in Austria on 100% of his or her income. Individual working days that are spent in Switzerland would be, or on these working days, Switzerland would have the proportional taxing right. Then I have some more examples. It is important to know that if an auxiliary activity is exercised by the employee, then this should not lead or should not trigger a permanent establishment. Auxiliary activities would be, for example, if an employee exercises IT services for the company. I'm now I now go to the second example. That is, if an IT employee of a German company works in an Austrian home office for the German employer, this would be an auxiliary activity that falls under under Article 5, paragraph 4 of the OECD model agreement. This would not trigger a permanent establishment in Austria. The taxation right would be fully in Germany. What is the difference to the first example? A group IT employee works in the Austrian home office. In this case, the employee works for the whole group and renders IT services for the whole group. Then this would lead to a permanent establishment, and a declaration and tax obligations in Austria would have to be filed. Yes, and the foreign employer, so the German employer, would become taxable in Austria. And the last example, a senior IT employee works in an Austrian home office. So this employee is in a management position, which is not considered to be an auxiliary activity within the meaning of Article 5, paragraph 4 OECD Model Agreement. This would also trigger permanent establishment in Austria, and there would be tax obligations in Austria for the German employer.
So I'm just jumping in here because, as you can see on the slides and what Siglinde already was telling us, it depends on the activities exercised or provided as well from the employee as well as from the employer. Because if we are talking in this case about an IT company, so then the IT activities provided by employees or management are not auxiliary activities anymore, because it's the main business of the company. So it's always depending on, on the detail, like almost every time in life, details are deciding.
Yes, for example, also auxiliary activities would be accounting activities for the employer, for example. So then let's go to the social security issues. Basically, the employee is subject to social security where the activity is carried out. There are two exceptions: if the employee is seconded or paid or works in several countries. Basically, the employee can only be covered by the social security system of one state. There is a threshold of 25%. I have an example here. For example, if an employee works in his Austrian home office but has a Swiss employer, and he works for an essential part from his home office, so more than 25%, then the employee would be covered by the Austrian social security system, and the Swiss employer would have to register in Austria for social security purposes. And in case of secondment, for example, for 2 years, the Austrian employee will be seconded to a Swiss company for 2 years. Then it is possible that the employee remains in the Austrian social security system, and this would not lead to a change of his social security system due to the secondment. Since the 1st of July 2023, there is a multilateral agreement between some states. Those are listed here on this slide, according to which an employee can work for more than 25% up to 50% in his home office state without changing the system. So the social security system, this would be the case, for example, if an employer would be in Austria, for example, and the employee works from his home office in Slovakia, for example, for more than 25%. So let's say 48% of his working time, then and the employee was always in the social security system of the employer state. So in my case, this would be in Austria, and the employee wants to remain in the social security system of Austria, then the 48% home office work would not lead to a change of the social security system to Slovakia if he wants to remain in the Austrian system. Okay, then please, the next slide. Yes, thank you. So there is an A1 form that needs to be applied for if an employee works in another state. This A1 form certifies that the employee is covered by his or her home country's social security system, so that the other state cannot claim for any social institutions. The maximum period the A1 form is issued is 24 months. It is to be issued by the Responsible Health Insurance Fund. And if the employee wants to be longer in the other state, for example, for 3 years, then there is the possibility to apply for the exceptional form for the period beyond the 24 months until up to for a maximum to 5 years. And then the employee, if this is granted, then the employee can also remain in the home country's social security system. And with some third countries, there are bilateral agreements for social security purposes, for example, with the USA. And they have also a form which is called AUSA-1 form that is to be applied for if the employee works in the USA. And this certifies the social security responsibility of Austria, so that the employee does not have to pay twice or in two systems, does not have to pay social security contributions in two systems. Yes, this was my part, and I will hand over now to Mr. Obernberger again.
Thank you, Sieglinde. So my part again now is about labor law and compensation. First of all, I would like to mention that we do have an in-house lawyer here at ARTUS, and she's specialized in this labor law and compensation topics. Unfortunately, she's not in the office right now. She's on vacation, so it's up to me, and maybe I need some support from Sieglinde. We will see, but I think we can cover almost the most important issues and topics. First of all, always a question is, what is the applicable law? Is it of the home state, of the hosting state? Yeah, what law can be applied, or which one to choose? In general, there's the free choice of law, but there are limitations, and the limitations are mentioned here on the slide. The free choice of law must not deprive the employee of the labor law protection she would have in the absence of a choice of law. The standard of labor law available to the employee at his or her usual place of work must not be undermined. So, and what happens if I do not choose a law? Then the law of the country in which the employee usually carries out his or her work, so more than 50%, or the law of the country in which the place of business is located. From a practical point of view, we strongly recommend, if you make use of the free choice of law, please take care that it will not end up in a mixture of two different national legislations, just because you opt in an additional legislation, because then it's from, for example, payroll perspective, pretty hard to cover both countries, because you all the time need to check what's better from the employee perspective. Yes, the next slide, please. Yeah, here I would like to talk about intervention standards, some minimum standards which must be complied within the country in which the work is carried out, and which in a public interest apply in all cases to the workers at the workplace for reasons of safety and health, irrespective of the applicable law. So these are mandatory in any way. Yeah, it's pretty common from my perspective, I think. So I want only to mention a few. It's about the protection against dismissal and transfer under the labor law constitution, rules on continued payment of wages, limitation of liability of employees, working hours and holidays, protection or special protection of young people, as well as for women and mothers. It's about the Maternity Protection Act. We also do have the Equal Treatment Act and special protection for disabled workers against discrimination, just to mention a few. And next slide, please. Yeah, of course, we do have some regulation about the minimum salary. To make it even more complicated, it's not a minimum salary stated in the law, let's say. It's a non-uniform regulation on minimum wage we do have in Austria, because the minimum wage is regulated in the respective collective agreement. And this means if you're hiring people, you need to decide what collective agreement is applicable, and then according to education skills, experience, and so on, then you can decide what is the minimum wage tariff for this special person. For posted and seconded workers, for the duration of the posting or secondment, compulsory entitlement to the statutory remuneration due to the comparable employees at the place of work. So this cannot be paid according to the home country. It must be paid at least at the level of the hosting country, in this case, Austria. We do have some business where are no collective agreements applicable, and then there must be appropriate remuneration at the place of work to be determined. So then it's about the business and the place in Austria, what are the appropriate remuneration for this kind of work provided by the employee. Yeah, then of course you need to file some notification for the employees who are posted or seconded. This is the, let's say, famous ZKO3 and ZKO4 forms. And this need to be filed at the AMS. It's the Arbeitsmarktservice. So, the next slide, please. Yeah, it's a very short slide just to tell you that there are no longer any restrictions due to COVID. So no proof of vaccination, no proof of recovery or tested or what else. So no restrictions anymore, even in public transport, hotels. Yeah, it's like before the pandemic. Yeah, thank you. You can go for the next slide. Yeah, we are almost at the end now of our presentation, and now we have some tips for the employer. Yeah, we are facing more and more that competitors are offering some cross-border remote working models. Yeah, we see this development. Yeah, please really check in detail if this offer really is in line with the compliance, with the Austrian compliance, because this, let's say, service providers are often not seated in Austria, so maybe they are not, pretty much into Austrian legislation. So, just be a bit, take care. Let's say it like this. From employer perspective as well, if you have some people working abroad, take care that you do have some clear guidelines, what the employee is responsible for example, taking care of his working day calendar, to be very compliant in these fields, give some guidelines, what are the responsibilities of the employee and the employer, just to avoid any, let's say, misunderstanding. And like you can imagine, this kind of misunderstanding always comes up if you split and you're not living as good friends, let's say it like this. Any other things to mention? The tax liabilities, social security obligation does not always have to be bad. So maybe some higher compliance costs are often offset by lower employer social insurance contributions abroad or ancillary wage costs that no longer apply in Austria. For example, employers' contribution is 3.9% of the gross salary. So it depends very much on the case at hand in the sense of what countries are involved, what are the activities. Yeah, and then it's important to have a good consultant at your side to be on the one side compliant, know the risks, and also to know the chances of a secondment or working abroad in general. Maybe the next slide. Yeah, you have to think about the higher, lower tax burden that the employee may face compared to his domestic situation. So then we are talking about tax equalization, tax protection, and this, of course, needs to be discussed with the employee before he's leaving his home country, because both sides need to be safe and on the same page. Same is with social security. Processing of one employee in a certain country is relatively expensive, but the marginal costs for additional employees are usually low, so economics of scale. Many of our clients are at the beginning pretty much afraid of establishing a permanent establishment abroad. From my perspective, it's easier to face it from the beginning and to know about, and because otherwise you always have the risk of creating a permanent establishment. And if you start from the beginning with the PE, you're pretty much on the safe side and you can handle it. You just need to think about a transfer pricing approach. But to be honest, from a practical perspective, again, usually if this is not a big business, it's just a few persons, then it can be handled pretty straightforward and keep simple. Yeah, roll out cross-border remote working concepts country by country and not with a big bang, because yeah, it's about getting used to it, even if it's the first country you're starting or the first employee. And yeah, it's like always, lessons learned and experience is crucial. And do not forget the labor law aspects. Relocation of activities to another country may mean that the mandatory labor law provisions of that country are subject to a favorability test. And in this case, I would also like to add, we do face cases a lot last couple of months that they're always trying to work with their home country contracts, even with people who are 100% in Austria. And yeah, please let it checked by a labor law expert. Maybe only some small amendments are required, but yeah, you can avoid a lot of stress at the end, because in Austrian market is pretty, let's say, employee friendly from a court perspective. So it really makes sense to invest a little bit of money to get the contracts checked from the beginning before the employee is starting working abroad. From our point, this was the last slide. I hope you did enjoy flying with Atos. And yeah, if any questions arise, please feel free to reach out to us or to conveners who will forward the question to us.
Thank you very much, both of you, and I'm so happy and relieved that we have you for taking care of all the Austrian aspects. I sometimes think that the Swiss ones are difficult to actually get your head around everything, but I think Austria is in some points even much stricter than we are in Switzerland. Thank you also all your participants for all the questions. There are a lot, and as said, I just will pick out two of them. One is about someone working from the home office with that new teleworking agreement. Is it correct that if we have someone working, employed in Switzerland and working in Austria for now those 49% of the home office, that there is a risk of permanent establishment based on your explanation? Mr. Obernberger, is that something you can say yes or no, or it needs to be a bit more looked into the details?
What I can say in general, that it's still not decided from High Court in Austria. We don't have seen any cases brought up to, so there's still in place, let's say, the opinion of the Austrian Austrian tax authorities. And they have the idea that the private apartment is a home office, it's used on a regular basis. And the employer is not providing any office space. And this provided office space, for example, if you're talking about Switzerland, Austria, it's not sufficient if the Swiss employer is providing an office, for example, in Bern, and the Austrian employee is living in Vienna, because then it's not usually that he will be in the Swiss office on a regular basis for normal cases. Yeah. So yeah, it's still a big risk to create permanent establishments by home office. But again, what I already mentioned, it's everybody's afraid of creating permanent establishments. To be honest, at least it's a risk that is covered. Then you have permanent establishment, you need to file a tax return, and that's it. And even if it's one employee, then we are mainly talking about cost plus 5% markup from a transfer pricing policy. So that's not a big deal. So you need not to be afraid of creating permanent establishment. You just need to be aware of it and to handle it.
Yeah, okay, understood. But it's, I mean, if I see the discussions we have usually with the employers, they do not really want to have people working that much from their home office, because they rather want them to be back in the office. And that might be also a good kind of argument for the employer to say there is a certain risk, and therefore you really have to kind of narrow down your days you spend in the home office to avoid the higher risk.
Yes, below 25%, there is no any risk at all. Between 25 and 50%, there is it's not clear cut, but if the employee works for more than 50%, then the risk is very high to create, and it always depends on the activity the employees is exercising. So if it is an auxiliary activity, or if it is the core business of the employer that is exercised in the home office.
Okay, perfect. So, the next and also last question we will discuss here in that event. And please don't worry, you will all get an answer to all your questions. Mr. Obernberger as well as Ms. Buttlinger will happily answer all of them. The second question is about an employee who has to install a machine in Austria. He's employed in Switzerland, goes there for the installation, and then will also have to do some service work, maintenance work later on. He is Swiss national. The question is now, is it correct that there needs to be done that posted worker notification, these ZKO4, and then an A1 needs to be requested, and then the employee is good? Or is there any other thing they need to take care or consider?
Yes, it has to be scrutinized if there are if the minimum salary is reached in Austria. Yeah, and if there are mandatory norms that have to be fulfilled from a labor law perspective, maybe. Like for example, yeah, holiday claims or bank holidays, etc. That would come to my mind.
Yeah, and again, from a PE perspective, it needs to be checked. What is the duration, if it is on a regular basis, and so on. Yeah. So PE, I would also check the PE. Yeah.
Okay, perfect. So thank you very much for today. And I just would like to use the last minute in telling you where our next work trip will go to. The next one will go to France, and we are happy to then be next time, as said, in France. So if you have still also afterwards now, after our event, some questions, just let us know. We definitely will forward it to artists so they can answer you and provide you with the expert information for your trips. Thank you very much, and I wish you a very nice week ahead.